So today's legal tip is property taxes, part two. Oconee County and Pickens County are out, so that's two more counties that have come out. Before I give you the legal tip today, I do want to give a real quick shout out to the Central Carolina Realtors Association. Taylor Kim are doing a kick butt job over there, big fan of theirs. They had a round table yesterday for all the brokers at the association. We met over at South Carolina Realtors Association, brought in the heavy hitters. They had Roderick Atkinson from the Real Estate Commission, brought a lot of great knowledge, and of course you got a ton of great knowledge from Byron King, who's legal counsel over at the association. So I was very proud to be part of that. The CCRA and South Carolina Association of Realtors believe in protecting real estate agents, and that's what Blair Cato believes, and that's what we're founded on. So we're very proud to be part of that yesterday. Now, as far as this legal tip, we got to look at it, two different contracts: the state contract versus the Central Carolina Realtors Association. The upstate contract, or the state contract rather, says that prorations will be reprorated. The parties agree to that if the tax bill comes out and it's different. So they agree to reprorate. When we do a closing up there, we remind parties, buyers and sellers, we can't control that. The real estate agent can't control it, and the lender can't control it. If one of the parties refuses to reprorate, there's really nothing we can do about it. We can send the prorations, but it's ultimately up to the parties to act in good faith for each other. We don't represent either party in that matter. Now, down here in Columbia, the CCRA contract's a little bit different. All prorations are final, but it does bring up an interesting question, because if we prorated at 6% and now we're prorating it, and the tax bill comes out at 4% after we have mailed the check, but before the money's been applied, who gets the refund? That's really not about a prorations. That's about who's entitled to a refund. So how Blair Cato handles it is, if we get the check back, and typically we do, because whoever pays the check, that's where they send the money back. So if we get the check back, what we would simply do is we would communicate with both parties through a letter showing them what the prorations would be at the new amount, and ask them to agree to a refund at that prorated amount, at the 4% amount. If the parties agree, we send the checks out. If they don't, we simply hold the money until they agree, send it to the court if there's an interpleader, or we send it to the state if no one claims it. Almost every time both parties agree to, let's just reprorate, it's the fair thing to do. So that's how it works. In Columbia, like I said, we don't have in a contract a provision that really deals with a refund. I think you could argue in the state contract that the agreement to reprorate wouldn't require the parties to, but nobody can really force them to do it. You as an agent, we as an attorney can't. Last thing I'll tell you is I met a really great broker yesterday at the meeting, and she said, I can't thank you enough for these legal tips, and how in the world can I ever show you how much I appreciate the legal tips. Two ways. One is, please send me your closings. If you like these legal tips, please send us closings and let us know that that's why you're sending the legal tips. And then secondly, ask all your friends to sign up. They go to blaircato.com, and there's a sign up at the bottom of the sheet. So get all the agents you can to sign up. Thank you. Hope you have a great weekend, and we'll see you Thursday night at our Oktoberfest. It's going to be a wonderful time. More information below. Take care.